SJC-11023.
All right, let's proceed.
Good morning, Mr. Chief Justice, and may it please the Court. Attorney Nicholas Plan on behalf of the appellant Todd Elia-Warnken. The issue before the Court this morning is whether or not the parties' Massachusetts marriage is valid under the laws of the Commonwealth. In terms of a very brief factual background, this case revolves around, in 2003, Mr. Elia-Warnken entering into a civil union out of the state of Vermont. That civil union was not dissolved. Sometime later in 2005, in the Commonwealth, Mr. Elia-Warnken entered into a marriage with Mr. Elia.
Was Mr. Baker alive at the time?
Was Mr. Baker alive at the time of the marriage?
Yes.
Yes, Your Honor, he was. At that time, in 2005, when Mr. Warnken entered into the marriage, he did not and had not dissolved the Vermont Civil Union. As of today, the record indicates he has not and did not dissolve that Vermont Civil Union. Nevertheless, the parties entered into the marriage and lived together for a period of 3 years, separating in 2008 with the filing of a complaint for divorce. Midway through the divorce proceedings, Mr. Elia filed in the probate court a motion to dismiss on the grounds that the marriage was not valid, indicating that the civil union made the marriage void ab initio because it was the existence of a prior marriage under Massachusetts polygamy statute.
Who filed for divorce?
Mr. Elia-Warnken filed for divorce, Your Honor. Mr. Elia then filed an answer and a counterclaim initially wherein he agrees that there's a marriage and a counterclaim for divorce. From our perspective, Your Honors, we turn first to the statute. The statute at issue with respect to this particular matter before the court is the polygamy statute, Chapter 207, Section 4, which says that if there is a former living husband or wife, then any marriage contracted while that former husband and wife is living is void ab initio. The position of Mr. Elia-Warnken is that he doesn't have a former living husband or wife. He has a former civil union partner, but that is not the equivalent of a husband or wife under the laws
in Vermont, that is considered a spousal relationship.
It is, Your Honor. In Vermont, it is considered a spousal relationship.
And it would be a violation of the counterpart of the polygamy law there, right?
Yes, he would. In fact, in the civil union statute out of the state of Vermont, he would be specifically prohibited from entering into a marriage while he was involved in a civil union.
So don't we have a comity obligation?
Well, I think the issue with respect to comity, my sister raises it in her brief, is a bit confusing because I think this area of law particularly, there is very little comity among the states and very little comity among the federal government and the state government. For example, if you look at the Saluco case, which is attached to my sister's brief, the Saluco judge says that there are 36 states that have adopted DOMA, which is the Defense of Marriage Act, which is something that obviously we in this Commonwealth reject. So there's very little comity between the federal government in Massachusetts. There's little comity between Massachusetts and 36 of its sister states. And within that group of states that haven't adopted DOMA, there are civil unions, there are domestic partnerships, and then there is same-sex marriage. So in this particular area of law, I don't think that there's a great deal of comity, and I don't think we can rely on the comity argument to justify.
Well, barring DOMA,
yes, Your Honor.
Setting that aside, what's the contention about comity? I mean, we're not going to do it just on the basis of adding up numbers.
Right, Your Honor. That's correct. I think the basis with respect to comity is that Massachusetts has never had this relationship. By statute or by case law, we've never adopted a civil union standard. We've never, ever enacted that relationship, and that relationship, although it's recognized for purposes of dissolution, has never been recognized really in any other way. And I think then, if we were to look at, say, Cody Whiteacre, where the court very clearly went through all of the impediments to marriage, the responsibilities of, for example, the clerks, to post the impediments to marriage, the existence of a former husband and wife is very clear. At that time, when Mr. Elia-Warnken certified that he didn't have a former husband or wife, he couldn't have possibly felt or believed that he did. And so he entered into this Massachusetts marriage under Massachusetts law, believing it to be valid.
In 2005, of course, Goodrich was already in effect, and Goodrich defines marriage as a voluntary union of two persons as spouses to the exclusion of all others. And doesn't the Vermont Civil Union statute meet that definition?
It does, Your Honor.
So what does that do to what you just said?
Well, I still think in terms of, in Vermont, he couldn't have gotten married, and I think that everybody recognizes that. But in Massachusetts, he can get married because he doesn't. In Massachusetts, there isn't a relationship that's recognized where he's entered into a relationship to the exclusion of all others. So in Massachusetts, there's no impediment to his being married under his entering into a valid marriage under the statute.
If you go ahead.
Apart from the use of the word husband and wife as opposed to spouse, I can't think of any good reason why we should do what you ask us to do.
Well,
I mean, it creates all sorts of trouble, and it's contrary to what would happen if he had remained in Vermont. Why is that? Why is that a thoughtful interpretation of the statute?
Well, I think from Mr. Elia-Warnken's point of view, I think we have a somewhat confusing situation in that when he entered into the marriage under the Massachusetts law, he believed it to be valid, and he did so under Massachusetts law. And now, some 7 years later after the marriage, where this court, or if we do what the appellee suggests, will apply Vermont law to Massachusetts. And I don't think he could have reasonably expected that to be the resolution.
Do we have any cases in which reliance prevails? That is, a person who thought that they had been divorced and for whatever reason legally had not been can say, because I thought I was divorced, I can still enter into a second marriage even though I'm wrong?
I don't think there are any cases that specifically address this point, because I don't think there's any appellate cases that address this actual issue where you have a civil union and you have a Massachusetts marriage competing.
I'm referring to traditional marriage, to marriage between a man and a woman, where somebody applied for divorce, thought they had been divorced, remarried, and turned out that they actually never legally obtained a divorce, or the divorce is not lawful, but perhaps because it was obtained in a foreign country and they had failed to follow the necessary procedures.
Well, I think, Your Honor, there are some cases, and I couldn't cite them at this particular moment, but I do think we have a line of cases dealing with the polygamy statute where we talk about after whether or not somebody's entered into a marriage in violation of that statute, what they might do to reform the marriage after, whether the relationship ends, what the other person's knowledge of that relationship status was, and we may, in fact, validate a marriage after that, depending on what the parties knew. In this particular case, the troublesome part of the record is that there was never an evidentiary hearing before the trial judge to determine whether or not two things, whether or not Mr. Elia-Warnken ever disclosed to the Department of Vital Statistics on the marriage application that he was in a civil union that had not been dissolved, and secondly, whether or not Mr. Elia knew that he was in a civil union.
Well, actually, the question Justice Gants asked was the one that he did it better than I was going to ask. But let me just follow up on that.
Yes, Your Honor.
If you say, well, the reason that you should do this is that your client thought that this was a valid marriage, and I take it isn't fair somehow to say to him that it isn't, that it's void. But he sought divorce, correct?
Yes, Your Honor.
So he wants to dissolve this union anyway.
Yes, Your Honor.
I mean, I guess I'm just looking at his own interests. What flows from whether it's void or whether he gets divorced?
Well, obviously, Judge, Your Honor, whatever property they accumulated during the course of the marriage and the distribution of that property, regardless of the title of that property. So, for example, let's suppose that all of the property that was titled during the course of the marriage is titled in Mr. Elia's name.
I assume that there might be some equitable considerations when you're talking about property. Probably where you don't have equitable considerations is alimony.
Exactly right, Your Honor. And even if you talk about equity considerations under filing a complaint for equity to distribute the property, you don't have the benefits of Chapter 208, Section 34, which delineate how that property will be distributed, nor do you have the benefits of alimony, as Justice Duffley references. So he's at a bit of a disadvantage on that. And in terms of the case law, as you referenced earlier, Justice Gants, one of the things that I think is most important would be Justice Spina's plurality decision in the Cody Whiteacre case, where we recognize comity and we recognize the effect that comity has, but we also don't do it to the prejudice of the citizens of Massachusetts. And in this particular case...
But there is a prejudice to Massachusetts here. And getting back to Justice Gantz's question, and you were talking about, what about these cases where in Massachusetts somebody had relied upon a statement from a person to whom they married that they were not married? It seems, my recollection is in those cases is that the marriage is void ab initio, but if the impediment to the marriage disappears, such as the death of the prior spouse, and then there is somehow a ratification by the other spouse, there may be a possibility of of that marriage becoming valid. Now, I'm not entirely sure, but that's my best recollection. And we have a whole set of a whole chapter of statutes that that treat the dissolution of a valid marriage differently from the dissolution or the supposed dissolution of a ceremony of marriage that never should have occurred in the first place, and that is other than divorce, it's I just forgot the name of the word. Begins with an A. Annulment. I mean, there's a whole procedure for these kinds of cases, in which all the equities can be addressed, and so it seems to me that's the route that should be followed here.
Well, but respectfully, Your Honor, not all of the equities can be addressed because, as we discussed with Justice Duffley a few moments ago, the alimony piece is out. And if these parties have a significant disparity in income, if these parties, one of them stayed home during the course of the marriage, and
but that would be true in a polygamous situation.
It would be, Your Honor. But this is, I submit that this is different than that, because at the time that these parties went into the marriage, if Mr. Elia and Mr. Warnken read the plain meaning of the statute, they would have concluded that there was no impediment to the marriage, and they would have relied on the plain meaning of the statute to enter into that marriage.
But the only reason, I don't want to speak for the majority of the court, but my sense was that the basic reason for saying that Massachusetts was going to recognize marriage as opposed to civil union was not because of the bundle of legal rights that was attached, but because of the stigma of treating people differently. And here, what's the difference between the bundle of rights in a civil union and the bundle of rights in a Massachusetts same-sex marriage?
Well, there would be no difference if Massachusetts adopts the Vermont statute. For example, Vermont specifically confers upon Vermont civil unions all of the rights and the privileges of the marital statute. So the dissolution, the application of alimony principles, the application of property distribution. Massachusetts doesn't have that. There's a difference
if a Vermont couple comes to Massachusetts, forget about somebody getting married again. If they come and establish residence in Massachusetts and one of them dies, they're not entitled to the laws of inheritance or the laws of...
To be perfectly honest with you, Your Honor, I'm not entirely sure if that civil union partner is entitled to inherit through intestacy under the laws of the Commonwealth. I'm not entirely sure. But we certainly do know this. They're not entitled to file a complaint for divorce to dissolve the marriage. They're entitled to file an equity petition to seek equitable dissolution of it. They're not entitled to seek alimony in Massachusetts because they wouldn't be husband and wife. And that's a big difference. And it might be a big difference in this particular case, depending on the factual circumstance of it. Now, obviously, there wasn't an evidentiary hearing before the trial judge, and we don't know all of the facts behind it. But that's a big difference. In Vermont, the civil union, the dissolution of the civil union under Vermont law would allow for the application of alimony principles.
Let me ask you this. Would you have the same position here if the parties had married in Vermont as opposed to a civil union?
No, I would not, Your Honor. I would think that if the parties had married in Vermont, then they would be prohibited from marrying here.
Has any of the other states that have not adopted DOMA addressed this issue of civil unions and then a subsequent marriage in another jurisdiction?
I've not found it. I think the answer to your question, Chief Justice Ireland, is two-part. First, I think that most of the states that have enacted civil unions or a more limited grant of a domestic partnership have, by way of statute, specifically excluded a future marriage. So in their statutory structure, they've said if you enter into one of these two relationships, you can't get married within those jurisdictions. So we have that. But we have not, my research in preparation for this and for the argument and for the brief, has not found a case where you have a Vermont a state civil union and a marriage from two different jurisdictions, and interestingly enough, both contracted while neither jurisdiction had the other. So, for example, when the Vermont civil union was contracted, Massachusetts didn't have civil unions. When the Massachusetts marriage was contracted, Vermont didn't have same-sex marriage. Now, subsequent to that, Vermont repealed its civil union statute and replaced it with same-sex marriage, and then said two things. It didn't automatically convert the civil unions that existed into marriages. It left those civil unions intact and said that if you wanted to enter into a marriage, if you wanted to you had to re-solemnize then your relationship as a marriage. So Massachusetts, of course, never had the civil unions. We went straight to same-sex marriage, certainly quite properly from my client's perspective. but they never really lined up. And so we have that interplay between the two. And so we have to decide ultimately, and I think the fundamental question is the question of comity. Do we take the Vermont statute and do we apply it in Massachusetts to people who didn't know, and I don't think reasonably could have foreseen, that when they got married on that day in Massachusetts, that husband and wife would somehow be later on interpreted to mean civil union partner in Massachusetts?
Let me ask you a question. I mean, in Massachusetts, we don't have common law marriage.
That's right.
If a man and a woman who had lived together in a state that did recognize common law marriage came to Massachusetts, what would they do if they wanted to dissolve their relationship? One of them could claim that they were in fact married and could be divorced in Massachusetts, and the other could say, well, we never solemnized the marriage. So it's not like Massachusetts never recognizes something that we don't have in Massachusetts.
That's correct, Your Honor, and I see that my time has expired. May I finish the question, answer the question? The Massachusetts recognizes other states' recognition of common law marriage according to our case law, so we do exactly what Your Honor says. We might at times apply the law of another jurisdiction to determine whether or not that marriage in Massachusetts is valid.
And so the question is whether we'll do that.
The question is whether we'll do that here on this particular instance. Right. And again, just as a final point, seeing my time has expired, again, those are marriages, and there is a difference.
Well, I mean, only because that's what they're called, but
exactly, and I think it's what the people.
So it's the term, not not actually the status.
It's the term, and I think it's also what the people, when they entered into the marriage, what the people believed, that whether or not what Mr. Elia-Warnken believed he had. Did he believe he had have an impediment to marriage under the plain language of the statute?
We'll have to leave it there.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, my name is Karen Lowy, and I'm here for the defendant appellee Richard Elia. It has always been the law of this Commonwealth that a person may only have one spouse at a time. General Laws, Chapter 207, Sections 4 and 8 plainly state that getting married when you already have a living spouse is prohibited, and any resulting marriage is void ab initio. Mr. Elia is asking this Court to apply these established principles to declare his marriage to Mr. Elia-Warnken void, because Mr. Warnken had established a civil union in Vermont with another person, Mr. Baker, which remained in effect at the time of the attempted marriage.
I take it there are a lot of civil union partnership statutes around the country, or a fair number.
There are a fair number. There are 9 states, Your Honor, that have established civil unions or comprehensive registered domestic partnerships, which are the same.
Are they all identical in this same regard?
They are all identical in that they extend to those partners the full scope of protections that a spouse could receive.
And prohibit anyone who's in such a union from marrying while they remain
That's
in that
correct,
union
Your
or
Honor.
partnership.
That's correct.
I'm sorry. I was just going to ask, in one of those situations, if the plaintiff had wanted, and he's in Massachusetts, if he wanted to dissolve the Vermont civil union, let's assume Mr. Baker's no longer in Vermont, just for the sake of simplicity. Could he do that in Massachusetts, or does he have to go back to Vermont to do it?
He could do that in Massachusetts, Your Honor. As my brother recognized, the courts, the probate and family courts, have been dissolving civil unions under their equity authority. I think it remains an open question whether or not they could do that pursuant to Chapter 208 directly. But in practice, in fact, the probate and family courts have been dissolving civil unions.
So that leads me to my next question, which is if we were to recognize, as a matter of comity, the Vermont civil union, do we then apply the Vermont polygamy statute, or do we apply the Massachusetts polygamy statute? Do we apply, in other words, what is comity extended to? Is it just the recognition of the relationship as essentially the equivalent of marriage in Massachusetts, and then apply the Massachusetts marriage and divorce laws and polygamy laws, or do we look back to Vermont and say, well, in Vermont, that would not be, under Vermont law, that would not be permitted?
I think as a general matter, Your Honor, Massachusetts applies Massachusetts' own law to address the incidence of a particular relationship once it has extended comity to the status. But more narrowly in this case, the question before the court right now is what is the meaning of General Laws Chapter 207, Sections 4 and Section 8, and whether or not the existence of a spousal relationship established in another state prohibits someone from entering into a valid marriage here, to which the answer has to be yes.
So I take it your view then is that the cleanest way to address this issue is to address it through comedy.
Well, I think comedy principles come to bear here, but I believe this is a direct application of the statutory terms. A civil union creates a spousal status. That's very clear under Vermont law. Under Vermont law, if you are a party to a civil union, you have access to all of the rights and protections of spouses, and you are included every time Vermont law uses the terms spouse, husband, and wife. And the same should be true under these provisions. A civil union creates a spouse, and therefore falls within the direct terms of the Massachusetts statute.
Are we saying then that a civil union is the equivalent of a marriage?
It is a parallel spousal status. Yes, functionally speaking, it is the equivalent.
But some civil union statutes, I don't think, extend all of the benefits of marriage. So do we look to each state to see how much we'll recognize? Or?
I don't believe that's true, Your Honor. I believe that the states that have established civil unions have, in fact, made clear in every state that has done so that all of the protections of spouses, to the fullest extent possible, flow to parties to a civil union or a registered domestic partnership.
Now, I asked your brother whether of those states that have not adopted DOMA, this is the first instance where a court has been asked to address this.
It is true that this direct question has not been presented to any of the other courts of states that do extend full marriage equality to their citizens. But the Court of Appeals of New York, the highest court of that state, has in fact addressed the parentage rights that might flow from a civil union by a couple that entered into a civil union in Vermont and subsequently gave birth. And the New York Court of Appeals concluded that the rights of parentage have to be recognized and that the child was in fact considered the legal child of both parties to that civil union.
But the only way that the court got there was not by applying New York law, but by recognizing Vermont's civil union statute as having conferred upon the parties parental rights.
That's true, Your
So
Honor.
they didn't apply New York law. They recognized, so they went further in applying comity. They didn't just recognize the relationship, they just applied Vermont law. Because under its own law, it wouldn't come out that way.
Your Honor, I don't believe they even tried to apply New York's own law to address the parentage question. They solely addressed the comity due to the parentage protections established by Vermont. But I believe that the same result, if in fact New York had extended comity purely to the relationship, treated it as a fully spousal relationship, it's certainly also the case that under New York law, a child born into a spousal relationship would be considered the child of both spouses.
I'm trying to sort out the comedy issue. Let's imagine that Vermont said you can have multiple partners in a civil union. Does that mean as a matter of comity that we would not apply the polygamy statute to them?
No, I believe that Massachusetts has to apply the polygamy statute to any parties seeking a marriage license here in the Commonwealth. The question is, does the person have a pre-existing spouse?
So we have to go beyond comedy. We have to say that our statute essentially says whatever may happen in another state, we do not permit polygamous marriage or civil union.
That's correct, Your Honor. The question before the court is the application of Sections 4 and Section 8 of Chapter 207.
And apart from the name, is there any difference between a civil union in Vermont and a marriage in Massachusetts?
Functionally speaking, no, Your Honor.
No, I don't know enough to even ask it. Go ahead.
Well, I want to address, Your Honor, the question that had been raised regarding the good faith of the parties, because, in fact, there is case law in the Commonwealth that addresses the good faith of the parties. And the good faith of the parties cannot transform a marriage that was void ab initio into a valid marriage. There may be equitable principles that come to play, whether it's with regard to a particular incident of the marriage or whether it's with regard to who has the ability to challenge the validity of the marriage. So the parties' good faith may have something to say about that. But this court recognized in Poor versus Poor that, in fact, that those estoppel principles or those equitable principles do not change the underlying invalidity of the marriage. And as the court has recognized, there are processes through annulment exactly to address those incidents. And this court should hesitate to do anything but what the courts of this Commonwealth have always done with regard to polygamous marriages, and allow the processes that are in place, whether it's, as the court recognized, Section 6, once the impediment removes, if the parties continue to hold themselves out as married, then that perfects the marriage. That's not the instance here, because the impediment is still in existence. But again, those principles, those same principles, should come to bear for marriages of same-sex couples as well.
Do the principles of comity, there were some suggestions, some of the answers earlier, that if we applied it here, we have to apply it across the country. That doesn't strike me as correct. Aren't there different principles that you look at that also look to whether the other nation, state, whatever sovereign entity we're looking at has laws that are repugnant or similar to, or would be recognized if the obverse were true, principles like that? Which of those come to bear here?
Well, so the way that Massachusetts has established its principles of comity are exactly that. Part of the inquiry is the mutuality among sister states. That's certainly the case. But the principles underlying comity go beyond that. It also goes to the settled expectations of the parties who entered into the spousal relationship in other states. While my brother claims that Mr. Warnken did not fully understand what it meant to enter into a civil union, again, the question of his good faith goes to the equitable principles, not the underlying validity of the marriage. It goes to the protections of comity flow to any children that may be born into a spousal relationship, and it goes to this state's respect for the determinations of its sister states, and the determinations of Vermont and 9 other states has been to extend the protections of spouses to same-sex couples through a parallel status. They have determined that status to be exclusive and comprehensive and consistent with this court's comity principles. As Justice Lank recognized, the parallel to common law marriages is exactly right. You have other states that have extended the full scope of spousal protections to people who have never gotten a marriage license, who have never gone through the solemnization process, but nonetheless, this court in Bolts versus Bolts recognized that that is a relationship that this state will extend comity to.
How do you account then for this in light of opinion of the justices, which rejected the equivalence of civil union and marriage?
This court's recognition in opinions of the justices that a civil union or a parallel spousal status couldn't remedy the constitutional violation of excluding same-sex couples from marriage is actually a separate inquiry from what this court should do and what this Commonwealth should do regarding a validly established relationship in another state. Comity in Massachusetts has extended to relationships that were expressly prohibited under Massachusetts law, that were never recognized under Massachusetts law, but nonetheless, because they were validly celebrated and validly entered in another state, Massachusetts has recognized them. So while establishing civil unions here in the Commonwealth was rejected as a means of remedying a constitutional violation, that doesn't render a civil union or a registered domestic partnership from another state to be meaningless. It is nonetheless a status.
Contrary to public policy in Massachusetts?
I don't believe its recognition is contrary to public policy at all. It is consistent with established comity law, and it's consistent with this court's recognition that our equality principles require equal respect for the legal relationships of same-sex couples.
And that's important in the comity analysis here. So I don't know the answer to this. For example, if you're too young in Massachusetts, would that be recognized here, marrying somebody who's 13 or 14?
Yes, Your Honor. If it is validly celebrated in another state, it has been recognized under this.
And how about the consanguinity laws, if you're too close in relationship?
Consanguinity and polygamy, in fact, have been, generally speaking, the two exceptions to the extension of comity.
So it does depend on how you view, how repugnant that is, the mutuality, perhaps.
Exactly right, Your Honor. But I think it's very clear that the public policy of the Commonwealth regarding the legal relationships of same-sex couples is one of recognition and respect.
Is the issue about consanguinity and polygamy because, in fact, they are specifically mentioned in the statute as
I think its origins actually are much more ancient than that, and the evolution of comity as a common law principle has ancient roots, and the language of the case law generally talks about those marriages that were repugnant to all Christian nations across the world, and something to that effect. So it is more the evolution of the common law principle, but I don't think, again, there's any question about the common law and of this state in terms of the recognition of the marriages and relationships of same-sex couples. One other point I would make about sort of the absurdity principle that we've been discussing of a construction that would not include civil union spouses, and that goes to the point of the 9 states that establish civil unions or registered domestic partnerships, and the other states that have extended explicit recognition. And that's simply a reminder that this is not just a contest between what happens in Massachusetts and Vermont. The reality is that if someone in the position of Mr. Warnken, who had a civil union from one state and subsequently married here in the Commonwealth, went on vacation in Rhode Island. They thought Newport was a nice place to go, and there was something tragic that happened. Newport Hospital, because Rhode Island establishes civil unions, would recognize the first spouse, not the marriage here in the Commonwealth. But if such a person went on vacation in the Berkshires, Great Barrington Hospital would now have a question. Do I look to the Massachusetts marriage, or do I look to the first spouse? And I believe, Your Honors, the only way to make sure that the underlying purposes of the Massachusetts polygamy provisions remain in full effect and are not completely deteriorated is to recognize that first spousal relationship as creating an impediment to the entry of a subsequent valid marriage in the Commonwealth. And for those reasons, if there are no other questions, Your Honor, I would just strongly urge the court to affirm the dismissal of the divorce action below.
Just one question. Was there I know that the judge ultimately dismissed it.
Yes, Your
Was
Honor.
there an opinion?
Not in any full form. He largely just granted the motion to dismiss.
Okay, thank you.
Thank you, Your Honor.